Hello, everyone. Good afternoon, and welcome to ReFashion first event. We have Mr. Terrell, who is the attorney advisor at the USPTO. She'll be giving our first training on IP and fashion design, fashioning your IP, what refashion businesses need to know now, not later. But first, I wanted to give a quick introduction to about what we do here at DSLBD, the Department of Small and Local Business Development. For folks who may not know what DSBD does, we support the development, the economic growth, and the retention of DC-based businesses, and we promote the economic development throughout the district's commercial corridors. And so we do that by a number of resources, small business resources that we provide to businesses and to folks who are thinking of starting their business here or expand their business here in the district. The programs that we have, I'll talk just a little bit, but I'll also drop our website in the chat if you want to read on more. But we have the CBE program if you want to become a certified business enterprise. That gives you preference points with the DC government for procurement and contracting opportunities. We also have our office hours at the MLK Library every Wednesday, where you can receive one-on-one small business consultations about, your business plan, business Canva, access to capital and financing, and other referrals to partners both within the DC government apparatus or outside of DC government, such as nonprofits and our partners such as USPTO. And I'll talk a little bit about ReFashion. So ReFashion is a initiative that just started here at DSOBD earlier this year, and that focuses on 4 fashion sustainability areas. The first one is technical innovation, re-commerce, textile alternatives, and the last is fashion empowerment. The mission for the ReFashion initiative is to, redefine, if not disrupt, what fashion was and what it must become to meet systematic challenges while supporting the development, the economic growth, and the retention of district-based fashion economy businesses. So I'll also send the flyer for the ReFashion initiative here for folks to read more about each of the fashion sustainability areas. And I'll introduce our presenter, Mr. L, who will be now presenting the training. Merceria?
Thanks so much, Javier. My name is Marisa Terrell, and I am so excited to be here to talk to you about 2 of my favorite topics. I'm really pleased to kind of kick off this partnership or collaboration with DSLBD. I'm from DC. I'm in DC right now, and I have for a long time believed that DC has a very unique place in fashion. And so, wow, this is a treat to be able to talk to you today. I know that we are probably going to be short on time, but I want to kind of walk you through a bit of how to think about protecting your fashion, your creativity, using intellectual property. And even if you're in the stage where you're sort of just in the iteration stage, it's really a good time to think about how are you going to keep your hands around what it is that you're doing so that you can monetize and so that you can enforce your rights. Okay, so that's what we'll be talking about today. So let's jump all the way in. So when you talk about fashion, I had a chance to teach fashion merchandising at UDC. And the way back then we were kind of defining fashion is like it's a dialogue. It's a dialogue between creatives and between consumers. But I think I like the definition that Takun gave. Now, Takun was one of those designers that was featured in the book, the movie September issue. I don't know if you saw the documentary. It came out a long time ago, but he talked about fashion and defined it in this way, which I think is so unique. Fashion as this capital F fashion, which is really talking about the prevailing style of dress for a particular time. That's more the traditional definition. But then he talks about this lowercase fashion. What is that? That would be like the spectacle. That's all of the surrounding things that sort of support this traditional kind of sewing process. So when you think about fashion with a lowercase f, you're talking about the theatricality, you're talking about the runway presentations, the television show, the museum exhibits, the fundraisers like the Met Gala, all of these other ancillary but super important parts of the fashion industry, you want to be able to protect those too, because that's also how you can cement your name so that people recognize who you are, okay, and that you can monetize that. So when you talk about intellectual property, though, what's that? Intellectual property, if you juxtapose that against real property, being land and buildings, or personal property, being like furniture or like a sewing machine, think about intellectual property as being the products of the human mind. This is really like that magic, that creativity, your spark, what you conjure up becomes like can be protected using intellectual property laws and regulations. Okay. So, as you're thinking about your arsenal, you're thinking about all of the different parts of your fashion business, your fashion intellectual property, your great ideas. When you think about them, you start to kind of think about what part of that is valuable, what part of that can be protected. Brand name, of course, right? Your online store, your personal name, your slogan, hashtags. But did you know you could also protect the shape of a handbag, the color of the bottom of a shoe, the print on specific fabric, maybe some embellishments, fabric technologies, your avatar that you use in social media, your customer list, your guest list. How about your CGI imagery or your reality TV show or your web series? Okay. All of those different goods and services can be protected using different types of intellectual property rules and regulations. When we drill down a little bit more, we know that typically fashion items, fashion services are protected by a bundle of intellectual property rights, from copyright to patents to trade secrets to trademarks and trade dress. We're going to talk about all of those today with a special emphasis on trademarks because I'm from the U.S. Patent and Trademark Office and I am a trademark attorney who's been practicing in this space for about 20, well, over 20 years. Okay, it's been that long. Wow. And so we're going to kind of focus and emphasize that right there. Okay. So let's get into some of these definitions because I want you to leave from this conversation with an idea of what these intellectual property rights are and how you can use them to protect certain parts of your fashion business. So let's get into copyright. Copyright really is, well, it's a way of protecting your artistic work when it's placed into a tangible medium. But interestingly enough, when it comes to fashion in the United States, apparel can be virtually, well, impossible to protect using copyright. Why is that? The idea is that copyright really is not supposed to protect functional parts of items or things like that. For example, um, we talk about useful items. Apparel is considered useful. It's not copyright protectable in this country. It is in Europe, but not here. So then, really, what are you sort of left with when it comes to copyright? How can you use it to protect what you have? Well, you can think about copyright when you're thinking about protecting sort of these artistic works. If you look at this Diane von Furstenberg dress right here, you can't really have a copyright on a wrap dress. That is considered a useful item. And so it can't be protected in that way using copyright, but you could protect the design, like the sort of like the artwork on the dress. So like in this instance, this repeating pattern, you can get a copyright on that pattern. When you see the next image here represents a case of a way to kind of get around that rule that you can't really protect a useful component of apparel. In this particular case, this is a 19, what year did this case come out? Let me see. This was, well, it's Star Athletica, and it's like a 2017 case. It's a Supreme Court case. And in this instance, there was a company that was making these cheerleading uniforms, but they had a really unique way of doing it. They created a silhouette, a simple cheerleading uniform, but they allowed their customers to be able to attach different embellishments to the uniform. These embellishments were like different shaped pieces of fabric that you could place on this uniform to give it to make it stand out and to become something that was unique to you. So I could add specific triangles someplace, or chevrons, or stars and stripes, or etc. These different embellishments, and of course, another company copied this use of these embellishments. So the original owner goes and escalates this case all the way up to the Supreme Court, and it turns out that using these three-dimensional embellishments could be protected by copyright because that was something that was considered like a sculpture or like an artwork. So isn't that unique? So right here, even though we know that copyright protection might not be available for apparel, there are some workarounds. You can protect the design of the fabric. You can also protect some three-dimensional embellishments that you might include on your apparel. One thing about a copyright, it's going to last the lifetime of the author plus 70 years. Okay, let's move on. What about a design patent? Okay, patents are also something that can be useful to you. We know that patents protect new inventions. But in the case of a design patent, well, they actually can protect the way an article looks. Isn't this interesting here? Take a look at this Stuart Weitzman shoe that's protected by a design patent. So that would be not the invention, but the actual way it looks. And even look here at this Calvin Klein versus Lululemon. This was a case. Lululemon has a specific way that they have the fabric folded to create a band across these yoga pants. And Calvin Klein also has a band. Lululemon thought that the band on Calvin Klein was a little bit too close to theirs. But imagine that you can protect even that sort of, you might in your mind think that that's not very unique. But in this instance, you can get a design patent on something like that. Design patents can be protectable for up to 15 years. All right. Let's look about something else. What about a utility patent? A utility patent protecting a new invention or a functional improvement on something, on an existing invention. It lasts for 20 years, and it can be a product, a machine, a process, or even a composition of matter. Okay, thinking about like Gore-Tex or Lycra. But what about this blouse fastener? All right. So if you're wearing a shirt and you want to prevent some gaping in the front, you might do what this innovator did. Her name was Rachel Behrens. She's a lobbyist, or was a lobbyist in Washington, D.C. She added some extra buttons and was able to get a utility patent on that, some hidden buttons that would be able to prevent your blouse from like opening up in the front. Some of you folks might understand what I'm talking about, but that's a really great tool, and that was a way you could protect it using a patent, okay? What about trade secrets? Trade secrets being like any information that's going to give you a competitive edge in business. Well, you can protect this information by keeping it a secret, okay? As long as you keep it a secret and you perhaps give your employees and folks that you encounter a non-disclosure agreement to keep it a secret. You might be able to protect this under trade secret. Let me give you two good examples that could help you understand this concept. When you think about Chanel number 5, the scent. Imagine that Chanel might have over time had a really great relationship with some of the folks who was growing the lavender or the lilac or whatever that's used to create this wonderful perfume. Okay, let's say that they over time they have a certain way of harvesting. They've got a certain way that they deal with their farmers. They've got a certain way that they produce and extract these oils from the plants, a certain way they get to market. All of those certain ways, those secrets, those things that give them a competitive edge can be trade secrets, and it can be something that you can protect so that if anyone misappropriates or tries to steal that, you can then have a way to recoup your losses so that you can sort of protect what you have. This other example right here is another good one. This was with Urban Outfitters. I'm just going to give you a very short synopsis of this situation, but actually it's Latote. Latote was a pioneer in the rental of fashion spaces to third parties. And at one time, they contemplated sort of selling their business to Urban Outfitters. So in that exchange, they gave up a lot of their information about what they were doing. Well, guess what happens? Urban Outfitters bows out of the deal and also begins to try to open up this same sort of concept of renting fashion space to third parties. Because Latote had an agreement, they were able to recoup losses and to sort of challenge what Urban Outfitters was doing, saying that they violated their trade secret arrangement. This they that Latote had really given some information to this third party, gave them some information to Urban Outfitters, and that they took that information that was really important to Latote. It gave them a competitive edge, and they were able to sort of prevail in a settlement. So it's so important to protect your trade secrets using contracts, using those specific non-disclosure clauses in contracts so that you can really be able to protect what you have, even when it's in the beginning stages. And this also goes for those business pitch competitions. You don't want to give away all of your secret information without having some sort of contract to protect and sort of make sure that folks are not able to monetize your process or your ideas or your competitive edge information without sort of giving you something in return. Okay, let's get into some trademark basics. We have run all the way through the different types of intellectual property, but you know I've got to emphasize trademarks because that's what I do. Okay, so let's get into what this is. Trademarks really protect, well, they protect any word, slogan, symbol, design, combination. A trademark really is anything that can indicate source or where your goods and services come from. They are, well, I'm going to show you some really great examples, but they are something that can not only identify where your goods and services come from, but they can distinguish your goods and services from others. It's a way that customers can find you in a saturated marketplace and then be able to then engage with you to perhaps purchase your goods and services. But they've got to first be able to find you, and that's what a trademark can help you do. Trademarks come in all different types. We have traditional marks, we have non-traditional marks, but these are some of my favorites right here. You see Nunori, this is like this virtual character, which who I love. I follow her. Now see, this is their trademark right here. The image of her in this circle is their trademark. Okay, this is a trademark that is owned by George Zuber, I think is the gentleman's name. And this is for, it's used on the Instagram account, but it's also used in like lots of different computer generated imagery, etc., to protect and to let others know that George is the originator or the source of the services that are offered here. Of course, there's Fenty Beauty for identifying cosmetics. Okay, this is owned by Rihanna. And so this would be their trademark. We have Rolex. We recognize that. Essence identifying magazines. We have even this pattern for Louis Vuitton letting us know if we see this on a handbag, we know that this handbag is coming from a specific place. Okay, we have the stylized C's for Chanel. We have the tote bag, Marc Jacobs. This actually is the logo, and we, even though we see the brand, the bags all over, but this is what he protected, this logo. And Pat McGrath, we cannot forget her. She's been in the news. I know everybody saw that Galliano show where he used this technique, this makeup technique of creating the models to look like porcelain dolls. One way to sort of capture that, to monetize it, maybe not through the actual technique in and of itself, unless that's protected by a trade secret, but surely the makeup that was used, Pat McGrath, a way to protect that. All these are different trademarks, okay? Trademarks can be traditional, brand names, slogans, logos, but they also can be something like a hashtag. I want to caution you, though, if you're trying to protect a hashtag as a trademark, it needs to really be used in a manner to indicate source of goods and services. So in this image right here, you see the hashtag being used on this glass. This is a storefront. The hashtag is used on the storefront to let folks know when they see this hashtag, they're supposed to think of this retail store that's made well, right? Is the company, okay? They're supposed to think about that. But just using a hashtag on your social media account, not necessarily trademark use. You've got to be using that trademark to identify goods and services that are offered for use in commerce, sold some kind of way in the marketplace, or services that are rendered in the marketplace. That's how trademark rights attach. So just because it's a hashtag, no go unless it's being used to identify specific goods and services, okay? There are lots of other different marks, sound marks, okay? You remember when Cardi B was trying to protect that oh sound, right? She was trying to protect that for use of different, well, she was trying to protect it just by saying it out loud. But the problem was she wasn't selling anything under that sound or offering any services under that sound. And so she was not able to get trademark protection. Their color marks, we know, we've talked about the red bottom sole, Louboutin. When you see the red bottom sole, you're not supposed to think of Yves Saint Laurent, okay? Even though they tried in that case, you're supposed to be thinking about Christian Louboutin. And so that protected color red could be a trademark. Scent, there was this case that I read in law school. There was a woman selling sewing thread, and all of her sewing threads smelled like lilac, no matter what color they were. She was able to protect that thread as a trademark. Simply that sound, I mean, that scent became the trademark so that you could walk down the aisle, right, in the sewing notion store and automatically think of this particular brand. So that can be really strong. We know that there are motion marks. If you've gone to an animated movie lately, you might have seen Pixar. They have that standard little motion where the Pixar lamp jumps on top of the eye and like shines this light into your face, right? That Pixar short little clip, a motion mark. All right. What about holograms on your American Express card, or maybe a configuration or shape of a product? I'm having a loss, but I'm thinking, of course, the Coca-Cola bottle would be a terrific example of the shape of a product being a trademark because it's something that you can use consistently. And so when a consumer encounters it over time, they will think of you. That's trademark use right there. So as you're thinking about how am I going to protect these fashion goods that I offer or these services that I'm rendering, think about some non-traditional marks that might be helpful. What about trade dress? Now, I really love trade dress, and I've mentioned it a moment ago. Trade dress, similar to design patents, refers to the look and feel of your product and service. It can't be, it must be non-functional. Okay, so it's something that everybody in your industry does not need to use in order to create or to use this product, right? It has to be something that's kind of decorative, that's not distinctive, that is distinctive, sorry, it can be decorative, but it must be distinctive. It must be something that's tied to your goods that when folks see it, they over time consistently see it, they'll think of you, okay? It could be the packaging, the shape, the stitching on your apparel, the color of the soles of your footwear, your exterior or interior architecture of your store. Imagine that. Let me show you some examples. Look at this buckle here, right here. There's a giant buckle here I don't know if you can see my cursor trying to, but there's a buckle and there's a Louis Vuitton bag. So that buckle is actually a trademark. When you see this buckle on a bag that it's Louis Vuitton, wants you to think of them and not Gucci or anyone else. So that use of that buckle, wonderful. So if you, as you're creating goods, think about what is the one thing that you're consistently going to use on all of your goods, something that can be turned into a brand, and you can protect it over with a trademark. The benefit of trademarks are, of course, that they can last forever, so long as you renew them every, the fifth year after your mark registers and every 10 years after that. Okay, we'll talk a little bit about more about that in a little bit. Here's that robin's egg blue for use in identifying jewelry. So Tiffany doesn't have it protection for that color for everything, but they do have it for jewelry. And so that's something that they are very litigious about. What about the store design? Do you know that this store design is protected by Apple? And no, so that no one else can use this particular design. And even when you go inside, the way it's laid out, that's also protected as trade dress, which is a type of trademark. Of course, there's that Louboutin shoe. And then look at this stitching on Levi's jeans. This particular stitching is actually a trademark. All of their jeans have this stitching, and so it's all a terrific way to protect these particular goods. Okay, and then here, right here, is a Hermes bag. Okay, notice that the part of this Hermes bag that's protectable, it's not the dotted lines, but it's the part of this bag that is not that is not dotted. That buckle is sort of like the where it has the locket or the lock that hangs from the clasp. That part of the Birkin bag is protectable. So sometimes you see other folks trying to create versions of this using the same type of lock or the same sort of band on the bag. Well, that would be trademark infringement, right? If you try to copy that and put that on a handbag. So that's protectable. And even the shape of the Chanel bottle, a protectable trademark, which is a trade dress. Okay, so let's figure out how then do you obtain these trademark rights? Because I hope that at this point I have proven to you that trademarks might be a way to go to protect fashion in this country. Lasts longer than patents, and it's a terrific option if copyright is not available. And we've talked about why it might not be available in the United States. So how do we protect using trademarks, and what are some of the rules and regulations that surround it? Okay, so trademark rights can be created in two ways, common law and federal registration. Let's talk about each. Common law rights are created as soon as you use your mark in commerce. So that means you come up with a great brand name, a terrific color, or a sound, or something that you're using to brand your goods and services. Once you come up with it and you attach it to goods, or you use it, you put it on a hang tag that's affixed to your goods. It's on the packaging for your products. You're using it in a way to advertise your services. It's on your website for where people are going to purchase your goods and services. As soon as you do that, well, you have trademark rights that are based in common law. Okay. But when it comes to common law rights, your rights are only as they only go as far as where you're located. They are limited to the geographic area as to where you are. That's a drawback. You get to use that TM though, as soon as you as soon as you're using these trademarks under common law, you can use the TM superscript or the SM superscript, trade TM for goods, SM for services, but these days we just reference mostly all of trademarks just by TM. Most folks aren't making a distinction between SM and TM anymore. Okay, but you can if you'd like. So at that point, you can use that TM superscript, even if you don't even register with us. Okay, so that's cool. Now, there's also a way that, oh wait, I blew past this, but let me make sure you saw that. You're not allowed to use that R in the circle if you're operating under common law, because that R in the circle signifies that you've gone one extra step. You are now, with that R in the circle, letting folks know that you registered your trademark with my office, the U.S. Patent and Trademark Office, and that's when you're allowed to do that. So let's talk about what kind of benefits do you get from taking extra steps to register your mark with us. Okay. Well, once you've registered your mark with us, you obtain federal registration rights. And what that means is that you are presumed when you have a federal registration, it's presumed that you are the owner, meaning you don't have to necessarily jump up and prove this every time you encounter someone. That R in the circle suffices to be prima facie evidence that, hey, you are the trademark owner. So that's good. Another thing is you get nationwide protection, right? As soon as you obtain federal registration, as soon as you register your trademark with us and it's approved and registers, well, now you are protected not just in the area where you are, but across the United States and territories. Another thing is when you have a federal registration, you can honestly tell someone, well, listen, I put you on notice that I have this trademark, that I'm using this trademark or using this mark or this slogan or this hashtag or this design and logo. I'm using it as a trademark. I put you on notice just by the fact that I registered with the office because when you register with us, you go through our process. And part of our process is your mark has to sit on the official gazette. And the official gazette is this place where your mark sits for 30 days before it's approved. And at that time, you're giving everyone in the world notice that yes, you are moving towards federal registration, and that's their opportunity to object. If they don't object, well, that's not your fault because you've gone through the process. And so that's why you can honestly say, yes, we put you on notice. All right. So, what are some of the rights and the benefits that you get? As soon as you register your mark with us, well, you can bring a legal action in federal court instead of state court. But you can also register your mark with U.S. Customs and Border Protection. Now, this is key. If you are an owner who is using your mark to identify goods that are constantly being knocked off, and these days, that's just about everything from handbags to pharmaceuticals, airplanes, shoes, etc., etc. Once you list your mark with the U.S. Customs and Border Protection, well, they'll be on the lookout for any goods coming into the United States that bear your mark. And if they find that these marks are counterfeit or these goods are counterfeit, they can seize those goods at the border. So that's good. You have sort of an army of people to assist you if you have a federal registration. And another thing, we know that when it comes to trademarks and trademark laws, every country has their own rules. And so it's really great to know that once you obtain a federal registration, you can use that registration as leverage to obtain registration in other countries. You can use our office as a one-stop shop for certain trademarks and trademark for. You can use our office, right, as a one-stop shop to obtain protection in other countries. Okay, so what do I mean by that? You could file an application with us. You can then use that some of that information to start the process in other countries for an additional fee and by filing some additional paperwork. And there's about 130 countries who've signed up to be a part of this network. We call that, it's through a treaty called the Madrid Protocol. But isn't that nice to know that you can kind of start that process with our help and walking sort of through those steps instead of going to each individual country to start on your own. So that's a great benefit of having a federal registration. Okay, I'm watching the clock and I know we're kind of running out of time. I'm going to maybe skip forward a couple of slides because I want you to have some really good information about our resources, but let me keep plowing forward. I'll just say here is that once you register your mark with us, well, now you can use that R in the circle. Okay, so the mission of the trademark office is to register marks, but your mission really is to select a mark that's going to sail right on through our application and review process. So you want to try to avoid two main reasons why your mark might be stopped in its tracks, and that would be likelihood of confusion and maybe your mark being too weak. So there's two concepts I want to run through. Confusion as to source is one. This is the most common refusal we issue. So that means you filed your application with us. An examining attorney has reviewed your application. They conduct a search of our database. And they might, what if they find something that they think is too close to yours? Well, they'll issue what's called a refusal based on the fact that there's a likelihood of confusion. The test that they use to decide is the mark, are the marks confusingly similar? Are they similar in sound, appearance, or meaning? And are the goods and services offered related? Okay. Are they related in some way? Here's an example of what I'm talking about. Remember this Adidas versus Tom Brown incident. So Adidas brought an action against Tom Brown because they thought that Tom Brown's stripes were a little bit too close to theirs, right? So the courts, in their analysis, they are using the same likelihood of confusion test. They're looking at the two marks. These would be these stripes. We have the red, white, and blue, and plus these other horizontal stripes, and then we have these Adidas slanted stripes, and they're saying, are they too similar? Do they look too much alike? And then they're going to look at the goods and they're asking, well, is athletic wear and athletic shoes, are they too close? Are they related? Well, here the court found that, yeah, they found that Tom Brown was not infringing, that they said that the marks were not too similar. Yes, the goods and services were related, but the marks were dissimilar. And so Adidas did not win this one, right? There was also a case with Birkin versus Meta Birkin. Birkin being Hermès, they have the registration for this actual the shape of the handbag, the way it looks. They have that protected as a trade dress trademark, and they also have the wording Birkin. And then here comes another gentleman, Mason Rothschild, who tries to create some imagery, computer generated NFTs that he's selling called Meta Birkin. And the court says, no, 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 that's too similar. The idea was our, when it comes to computer generated items, are they, is that something that we can even compare and contrast? If we're not talking about real goods, we're talking like about computer generated things. And the court said, no, here there's going to be a problem as well. Okay. Commercial products. Are NFTs commercial products? That was the query here. And the court found that there was a problem. There was a likelihood of confusion. Okay, so as you are doing your own search, before you file your application, because we recommend you do that, you want to be asking yourself, are the marks that you're finding the competitors, are they confusingly similar? Are the marks confusingly similar? Are they similar in sound, appearance, or meaning? And are the goods offered related? Now think about Dove, right? Just because marks are identical doesn't mean there's confusion as to source. In this instance, Dove is used to identify soap, but it's also used to identify ice cream. And there's no confusion there, right? You're looking at the goods, ice cream and soap, they're not related in any way. I can't even think of one brand that sells soap and ice cream under the same branding. I cannot think of one. And so the idea is that they're not related, so they can coexist. So you want to be thinking about that type of analysis as you are coming up with your brands and using them in commerce. All right, so you want to be sure you conduct your search using our database. We have a brand new trademark search system. I invite you to visit our website, uspto.gov, and to visit our search mechanism. But when you search, you want to make sure you search our database for any marks that have been applied for or registered with us. But you're also going to search the internet because you got to be sure to find those common law users, those folks who've never have never registered their mark with us. Okay. I want to sort of run through quickly. This will take me about 2 more minutes, Javier, and we're going to almost be done. I'm looking at the thumbs up. Okay. Another common reason why your mark could be stopped in its tracks, okay, is if it's too weak. And infographic is showing you weak marks to strong marks, okay? You want to stay in the red zone, which is the strong mark zone. So what are some examples of the weak marks? You don't want to pick a generic term. Generic terms are terms that everybody in your industry is going to need to use to identify the goods. These are those common everyday names. So trying to name your company Blouse, if you're selling women's apparel, not a good idea. That's a generic term that you're going to have. It's actually not even a trademark because it does not indicate source because When a consumer sees it, they are not thinking about you. They're thinking about the definition of that term. All right, so stay away from the generic terms. Descriptive terms. These are terms that describe something about your goods and services. So Victoria's Secret has a trademark for pink, okay? Pink is a descriptive term because it can describe the color of lingerie. It could be pink, all right? How were they able to get a registration even though the mark is descriptive? Well, I'm not sure in their case what they did, but I can tell you that for descriptive terms, if you're able to prove that your consumers over time associate this descriptive term with you, you might be able to obtain trademark protection. But good grief, can you imagine the number of cease and desist letters you'll be writing all the time because people want to use that descriptive term because it is a weak term. So be careful about that. You will be policing that mark forever if you select a weak term. What about suggestive terms? If you're in DC, you know all about New Balance. That's a brand of sneakers we know and love here. Okay, New Balance is suggestive because it takes a bit of imagination to figure out the goods and services that are offered. New Balance, this was a registered trademark. You think about balance. You're trying to balance as you're running. It's something new. New Balance. There's a lot of steps to try to get to what the goods are. Great, strong terms. What about arbitrary terms? These are terms that have no association with the goods, except for the one you created. Rag and bone is a great idea. These are real words in the dictionary, but who would have thought to identify a clothing brand by these terms? Well, these owners did. Very, very strong. And what about fanciful, made up terms like Lululemon? That combination made up. The owner put it together for a variety of reasons. He liked that alliteration, etc. Fanciful, strong. Okay. This is the trademark application process. Not a lot of steps. You can take a look at this information. It's on our website. And I want to just talk about price. And I'm going to keep this up. These are all of the requirements for obtaining trademark protection through our system. And let's talk about how much it's going to cost. When we think about trademarks, your application, you're going to need to provide your mark. We call that a drawing. It's a depiction. It could be in standard characters, all letters, or it could be a logo, okay? Or it could be a color, or even a scent, okay? You're going to give us your listing of goods and services. You must tell us what you're going to use that mark to identify. You have no trademark unless it's identifying specific goods and services. So if it's apparel, you'll have to say, is it hats, shoes, jackets, coats? You have to list all of that out. You have to tell us your bases. Are you filing because it's something you're intending to do in the future? You're intending to use your mark to identify these things? Or are you using your mark now? You have to let us know. You have to give us your contact information. We need an email to contact you, and we need a mailing address, and then you need the money. When you talk about the money, $250 is the least expensive way to file with us, but it's $250 per class. All right? How do you know? Well, we classify all goods and all services in numerical classes 1 to 45. And so when you think about goods and services, I want to give you some examples of what that pricing might be. So if you are an apparel company, think of all the types of goods and services that big brands offer. Sometimes they offer cosmetics. We classify those in class 3. So that's one fee of $250. If you're offering sunglasses, class 9. So now you got two classes. Now we're at 500, okay? What about if you're doing jewelry? That's class 14. That's $250 more. And if you're doing the apparel itself, class 25, now we're at 4 classes. And what about retail store services in class 35? You see how it adds up. That's 5 classes at 250 per class, okay? So it can be expensive, but you don't have to do them all at once. You can pick one and then refile and pick another. Okay, at this point, I want to go ahead and sort of close this out. I'm going to get to a screen where you can see some resources because I want to make sure I can answer some questions. Okay. Javier, as you get ready to come back on, let me see if I can't. One thing. I think I'm going too fast. Well, no. All right. Let me keep moving forward. I'm sorry to keep flicking this screen like this. For those of you who don't like all these flashing images, my apologies. The only requirement that you have once your mark registers is to renew it. The fifth year, so the day your mark registers, you count 5 years into the future, you're going to pay a fee there and file some documents saying, yes, I'm still using the mark. And then every 10 years thereafter. Okay. It's your job to enforce your mark. Unfortunately, the USPTO does not do that work. We register marks, and so once you obtain that registration, we sort of step out of it, and then it's up to you to enforce your mark with maybe the use of an attorney. We recommend always using attorneys as opposed to some of these third-party companies that are not necessarily vetted. Okay, Javier, um, I want to give you an opportunity to jump in with questions because I know I raced all the way through that. I can't hear you if you're talking.
Sorry, I forgot to mute. Thank you so much for the outstanding presentation, Marisha, and the great uh, um, wealth of information. So we appreciate your time and the presentation. We do have some time for a
Okay.
couple of questions,
Okay.
if you don't mind. Um, I'm just going to go back into the chat here. Let's see. First question. Is it true that you can make red buttons under a certain amount?
Red buttons? I'm not
Yeah,
sure I understand.
yeah.
Oh, red bottoms.
Red, oh,
Red bottoms. Is it
bottoms,
true
yes.
you can make red bottoms
Yeah.
under a certain amount?
Sorry, I didn't have
Louboutin,
my reading glasses
oh,
on.
that's all right. Louboutin has a trademark for the red soles. Their trademark is for red bottom on a shoe. They have that trademark. So if you are making shoes with a red bottom, you are violating their trademark registration.
Okay. And I think there's another question in regards to non-traditional trademark and if somebody already owns it. So the question is if you have an idea for a non-traditional trademark and somebody owns it, can you reach out to the trademark owner to ask for permission? And this is referring to the trade dress, actually.
Sure.
Yeah.
So unfortunately, even though I'm a lawyer, I'm not representing you, Nicole. So unfortunately, I can't give you legal advice, but I can tell you that you absolutely, no one can proclivit, pro, prevent you. Nobody can prevent you
Yeah.
from contacting someone else. But just think about what it is that you're doing when you reach out to them. You're kind of letting them know what you're up to. And so you want to think that through as to what it is that you're doing. But you can always reach out to people and get permission to do certain things. So that's not a problem. But you want to make sure you're thinking 5 steps ahead as to what that might mean, and what it is that you're communicating when you do that. Okay.
Okay. And I think the couple more questions. I believe this one was already answered in during your presentation as far as like the length of the um, what is the suggested amount of years? So the writer or the question is, I heard Louis Vuitton won his trade dress because of the length and the notoriety of his brand. Sorry, I mispronounced that. How long should our brand consistently use the trade dress?
Right. Okay. So understand that remember what I was saying is that trademarks attach as soon as you begin using your trademark to identify. So let's say that you had the great idea that you wanted to use the color yellow on the boxes of your shoes. So your shoes always are going to be shipped and given to people as a yellow box. So yellow is your color to identify shoes. Once you start doing that and you're offering shoes and use for use in commerce, you're transporting the shoes across state lines, you're selling them on the website, whatever. you've established use in commerce. At that point, you have common law rights.
Mhm.
Now, if you decide to register that color with my office and you obtain federal registration, at that point you have registration and protection. It's not about length of time that you're using it. Once you start to use it, you have trademark rights. Once you register that mark and it's approved, you have trademark rights. So part of what Louboutin was doing in the case, of course, he was trying to prove that yes, that color, folks really do understand it. It's a trademark. And I
Mhm.
have all this evidence to show. I've got all these surveys. Here's like all these people talking about it. I've got magazine articles and celebrities all talking about red bottoms. He was able to justify that, yes, people do use it, but understand the trademark rights attached a while ago. His case was unique because it was unusual for people to use color in that way. And so that's why he had a sort of a more of an uphill battle. But now
Mhm.
that he's kind of provided some precedent, it makes it easier for the next person to do the same. Okay.
Got it. And the last question is, if you make shoes, should you submit your trade dress application for every design? I believe it was trademark application
So
under
you
that.
can, so if you're trying to obtain trade dress, not patent, remember patent, we show an example of patenting a shoe um, under a design patent. You can do that, but you're limited. It only lasts for a certain amount of time, right? I think it's 15 years, if I remember correctly. But if you're trying to use trademarks to protect, then that means what you're saying is that your shoe necessarily is not going to change each time. Because remember, a trademark means that every time it's something that a consumer gets used to seeing associated with your goods and services that makes them know this is your brand. So think about it. Is there something about you, something you put on a shoe consistently, no
Mm.
matter what shoe it is, that lets somebody know it's yours? Is there a specific stripe you use, like Adidas? Is it a specific color on the bottom of the sole that doesn't change, like Louboutin? What is it about your shoe? And that's what you protect as a trademark, as trade dress.
Okay. Wow. I didn't learn. I learned something new there. So about the color and the common law um, right, I believe.
Correct. Yeah.
Yeah. So wow, that's really interesting there. Marisa, thank you so much. So before we end it, is there helpful? You mentioned a website. I was able to drop it in the chat here, the uspto.gov site. But is there any other information that you want to share to the
Yes,
audience?
please. Let me just share this information here because it's really important that folks are aware that there are scams out here, and I don't want you to get duped. There are a lot of third-party companies out here saying, we'll trademark your brand for $50. We will conduct a search for you for $40. Contact us. Da, 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 da. Right? This is happening all the time. We just want to remind you that the U.S. Patent and Trademark Office, our fees are $250 per class. So no one can offer anything cheaper than that. That's the least expensive option. We have a listing of third parties who are bad actors on our webpage that you can take a look at. The way they generally get you in is they say, we'll design a logo for you. And then they'll say, oh, by the way, well, let us help you trademark. Understand that if they're not a lawyer, they cannot file an application for you. A
Mm.
paralegal cannot file an application for you, but you can file one for yourself. Otherwise, you really need to think about contacting a lawyer to file on your behalf. All right. Think about that. It's very important. We don't want you to get um, duped. Another thing I want to bring up is that trademarks the process. This is a legal proceeding, and so it can be complicated, but there are places that you can go for support. If you like videos like this, you can participate and by watching videos with me and many of my colleagues at uspto.gov. You can look at videos. You can see our registration toolkit. Okay. We have a basics boot camp on Tuesdays for an hour with 30 minutes for you to ask questions with trademark experts that work in the office. We are right now approaching week 4 talking about application requirements, but we walk you through the application. We show you how to use the search system, etc. So I hope you'll join us. Um, why is this over here? Okay. Also want to show you free resources. Okay. uspto.gov /free resources. You're going to see a map. You can click on Washington, D.C., Maryland, or Virginia. It'll show you some law school clinics that are available to offer free student attorneys to help you file your application and conduct a search. I used to manage the clinic at Howard University School of Law, so you can go over there and speak with Daryl Motley. He's on the patent side, or Eric Pelton on the trademark side, and get some free assistance there. Very helpful, and you can find that information right there. Or if you want to speak to someone one-on-one, you don't want to be bothered with emailing necessarily. You want to talk to a live person in real time. You can call our Trademark Assistance Center from 8:30 in the morning to 8 p.m. at night and ask them a question, and they can help. Can't give you legal advice, but they can walk you through processes, help you determine whether something you received was a scam, show you where your file is, what's due, and when, those kind of things.
Great, thank you, Marisa.
Okay.
And if you don't mind, would you be able to share those and so I can vet the resources so I can send it out to our participants in a follow-up email?
Oh, absolutely. In fact, I can even provide you with this deck if you want it. But yeah,
Oh,
I'm absolutely able to share that. I'll follow up with an email for you.
mhm.
And I just really appreciate the opportunity. I know that that was a lot of information, but really all I was trying to do was to give you like an overview.
Mhm.
And so with this information, hopefully you're feeling confident enough to start the process and then to hang out with us some more so that we can walk you through some of the specifics.
Definitely. Thank you so much. I always believe in empowering everybody about information and resources so they can get the tools needed to help in their business journey. So we appreciate your time and thank you so much for devoting some time for our audience here. So yeah, we'll follow up with the resources that Marisa has provided and USPTO resources as well, with a follow-up email for our participants. And thank you so much, everyone, for attending the training, our first ReFashion training event here. Appreciate that. Thank you so much. And everybody have a great weekend. Thank you. Bye.
Bye-bye. Thanks so much.